Good afternoon. My name is Margaret Raymond, and I'm the Dean of the Law School here at the University of Wisconsin. It is my great pleasure to welcome you all to our annual Kastenmeier Lecture. Thanks all of you for being here. This lecture is supported by the fund established to honor Robert W. Kastenmeier, who graduated from our law school in 1952 and then served with great distinction in the United States Congress from 1958 to 1990. The fund was created to recognize Bob's contributions by fostering legal scholarship and conversation in fields that were significant to his career as a legislator, which, if you know anything about Bob, ranged widely and included improvement of the judiciary, the field of intellectual property, corrections, the administration of justice, and civil liberties. We have a dedicated planning committee for the lecture, which is now chaired by my colleague Anuj Desai. Anuj, are you here? There he is. And every year the committee devotes serious effort to finding an extraordinary speaker who can address one of the many areas in which Bob made his profound contributions. When I first began here in 2011, one of the fixtures of the lecture was the presence of Bob Kastenmeier and his wife Dorothy at the event. Last year they weren't able to attend, and so Professor Desai and I went by and had lunch with Bob and Dorothy and shared news about the lecture with them. And as you all know, we lost Bob last year. So this is the first year he can't be here with us, and we can't share news about the event with him. Bob, we miss you. And I'm very sad that he's not here with us, but it is really inspiring and moving to me that the lecture will continue, and it's especially significant given the exciting talk that we're able to present today and the stature and importance of this year's Kastenmeier Lecture. To introduce our speaker, I'm going to call on Mike Remington. Mike is of counsel at the firm of Drinker Biddle in Washington, D.C., and a 1973 graduate of this law school. He's an intellectual property lawyer, and for 9 years was chief counsel to the Judiciary Subcommittee of the U.S. House of Representatives on intellectual property and judicial administration. While his resume fills many pages, the most pertinent aspect of it for our purposes today is that he was a longtime aide to Representative Kastenmeier. Please join me in welcoming Mike to the podium to introduce our speaker.
It is my distinct honor to introduce Congressman Jim Sensenbrenner. I've seen Jim at work since 1980. Almost in an uninterrupted way, and I stand in awe of what he does. If Bob Kastenmeier was here, he would have stated a couple initial words, laudatory words about the speaker, which was his practice ever since the first Kastenmeier Lecture, when Chief Justice William Rehnquist gave the lecture at the Memorial Union. As a weak stand-in, please know that the Kastenmeier Advisory Committee discussed having Jim Sensenbrenner as a speaker, and Bob always responded positively to that, although he sometimes had a quizzical look on his mind. Dorothy Kastenmeier could not be here today because her son Andrew, who lives in Brazil, is visiting her in Arlington, Virginia, but she specifically asked me to thank you, Congressman, for presenting this lecture. You already have access to a Sensenbrenner bio, and a short bio, I think, is in the program. Jim completed his undergraduate studies majoring in political science at Stanford University. In 1968, he received his law degree from this law school. After law school, he served for 10 years in the Wisconsin State Legislature. And after that, he was elected in November of 1978 to the U.S. House of Representatives, and he has served interrupted ever since that time. Like many Wisconsinites, Congressman Sensenbrenner is understated. Wisconsinites, I know this from afar, they never sing their own praises. So I am going to sing your praises. Jim I've seen him in action. I hope I won't embarrass you, Congressman, but you are ethical, smart, devoted to public service, and committed to the rule of law, both domestically and internationally. We know you're a strong family man. We know also that you love the Packers and presumably the Badgers. And I could stop right here, but I want the audience to know that I think that you, and this is agreed to by others, one of the most illustrious grads from this law school. The Patriot Act, you've had accomplishments in several areas, and I'll allude to some of them, but your chairmanship of the House Judiciary Committee for 6 years and your chairmanship of the House Science Committee were sterling and effective. You understand the merger, the intersection between law and technology, and Congress is in dire need of people like you. And the Patriot Act is only one example of the Congressman's legislative prowess. You have a strong record, and I could go on, but in the area of congressional oversight, with achievements in criminal justice, impeachment, judicial discipline, intellectual property, and constitutional issues, including voting rights. Your accolades, which is a test of one's effectiveness, are long and numerous, and I'll just mention two. The Association of University Technology Managers recognized you for your work on patent law and technology transfer, issues of great importance to the economy of the state of Wisconsin and to this university. In an August ceremony at the Japanese Embassy, I saw you receive the Order of the Rising Sun for deepening the Japan-U.S. alliance through the promotion of mutual understanding. The Kastenmeier Lecture was created to promote scholarship and understanding about national public policy issues. The goal was to bring Washington, D.C. to Madison, Wisconsin. By inviting Jim Sensenbrenner to appear today, you not only invited a successful grad and an effective Wisconsin representative, you've brought a wealth of national and international knowledge and experience to this room. I could go on, but as they say in Congress, and I know you would do this to me, you would tell me that my time has expired, and I will give you the floor.
Mike, thank you very much for that very kind and generous introduction. As you know, I've got two alma maters. One is Stanford and the other is UW-Madison. And about 4 years ago, Stanford and the Badgers played against each other in the Rose Bowl. And I had tickets to that Rose Bowl, and I was really wondering how I would answer the news media if they asked me who I was rooting for, or whether I was, a bit bipolar and rooted for one in the first half and the other in the second half. Unfortunately, that was the day that the Ryan Murray fiscal cliff avoidance bill came up. So instead of spending New Year's Day watching the Rose Bowl, I spent New Year's Day watching it on television, waiting to be summoned across the street to do the job that I was elected to. Hopefully, those matchups will not occur again. I'm also very honored to be selected to give the Kastenmeier Lecture. The first dozen or so years that Bob and I served together, the press had a field day because we usually canceled out each other's votes on the Judiciary Committee. And particularly one newspaper in Milwaukee and another in Madison, each city had two at the time, as you may recall, always liked to play the two of us off against each other on issues that were partisan or ideological nature. And finally, both Bob and I decided that this was counterproductive to us working together. And it didn't take more than a couple of months of declining those interviews when the news media decided to move off and to start asking questions on other stuff. And we did agree on a lot of things, one of which was to stop a law being passed to turn bankruptcy referees, as they were called at the time, into Article III judges with lifetime tenure. Both Bob and I thought that that was an awful idea, and we were able to stop that. I am honored also, and looking at the number of judges that are here today, we have a quorum of the Supreme Court, we've got state appeals judges, we've got state trial judges, and I don't know if the Supreme Court's violating the open meetings law by having a quorum present, but that's up to you judges to figure out through your interpretation. But this, really is a high honor that all of you are here today. And I hope to be able to at least scratch your intellect talking about the Patriot Act, its history, what motivated me, and how the Freedom Act ended up getting put together. I will say with a great deal of gratitude that this is the first time in my life where I've had a bunch of appeals judges listening to what I've had to say and they can't interrupt me. Yes, Your Honor. But there will be time for questions because I did see Justice Abramson up at Justice Crooks's funeral, and she said she was going to come here, and I thanked her. And then I said that Professor Desai asked me to speak for an hour. And she said, that's terrible. Said it won't be that. Then she said, will there be time for questions? And absolutely. So again, thank you for this suggestion. And now if I don't speak for an hour, I can use you as a crutch for having a quicker speech. So here goes. I don't know if it was fate or just bad luck, but circumstances conspired to place me at the center of the last two major revisions of our nation's surveillance laws, the USA Patriot Act and the USA Freedom Act. The names intentionally echo one another, by the way. The two bills are viewed differently. The people who praise me for passing the Patriot Act condemn me for passing the Freedom Act. And the people who condemn me for the Patriot Act are singing my praises today. But that's the nature of this business. And I've always believed that if I'm upsetting everyone a little bit, I am probably doing something right. But for me, the Freedom Act was not a great departure or ideological shift from the Patriot Act. They are different bills that were passed in very different political climates. But in both cases, I steadfastly refused to be in either the privacy camp or the security camp. Then and now, I believe that we could defend both our country and our liberty. Both laws represent my best efforts to protect the national security of the United States and its people to the greatest extent possible without compromising our constitutional rights or values as a nation. The final draft of the Patriot Act was bipartisan and passed the Judiciary Committee unanimously. It was because the Patriot Act was so carefully negotiated that I took such offense when the Snowden acts were revealed. The first leaked Snowden document was an order from the Foreign Intelligence Surveillance Court, which we called the FISC, directing Verizon to produce on an ongoing daily basis all call detail records, primarily who called whom and how long they talked, on every call to and from every American made either to, from, or within the United States. The FISC granted the order under Section 215 of the Patriot Act, the so-called business records provision. Section 215 allowed the FBI to obtain tangible things when, among other requirements, there were, quote, reasonable grounds to believe that the tangible things sought were relevant to an authorized investigation. The production of all records in bulk did not square with 215's requirement that the records be relevant to an authorized investigation. Relevance is not a high legal standard, but in crafting Section 215, we had contemplated a targeted authority that the government could use to obtain specific data. Now, how could everything be relevant? And if everything was relevant, what were the practical constraints of Section 215? Both the Bush and the Obama administrations convinced the FISC that in creating a relevant standard for the production of records, Congress intended to allow the government to collect anything it wanted. We'll dive deeply into the legal arguments for that, but the basic pitch was we need everything so we can determine what we need. There are, of course, times when the government must, for investigative purposes, obtain more documents than just those that it ultimately needs. In the government's words, relevance is a broad standard that permits discovery of large volumes of data in circumstances where doing so is necessary to identify much smaller amounts of information within that data that directly bears on the matter being investigated. Unquote. A real mouthful. While this statement is overbroad, it does describe how the government may need to collect a certain volume of records for investigative purposes. Imagine, for example, that the FBI receives a tip that a potential terrorist purchased a large quantity of fertilizer to build a bomb on a farm near Madison. Because the FBI does not know who the suspect is, all large fertilizer sales in Dane County over a reasonable period of time may well be relevant to the investigation, at least until the FBI determines which sale was actually made to the suspect. The administration therefore argued that because communications metadata is interconnected, and because connections between data points can only be analyzed from a large volume of data, the entire data set is therefore relevant. In other words, for the government, all of our phone calls are like fertilizer sales. That reasoning, however, is fatally flawed. First, in the fertilizer hypothetical, there are stipulated facts that differentiate relevant fertilizer sales records from those that are not relevant to the investigation. Section 215 expressly calls for this by requiring that the government produce a statement of facts showing that the tangible things sought are relevant to the investigation. If this required statement of facts means anything, it must require that the statement of facts differentiate the relevant materials from the universe of all similar records. In our hypothetical, the government is not claiming a right to all fertilizer sales records. It is bringing forward facts to show that it has a legitimate reason to investigate fertilizer sales from a particular location. The statement of facts therefore separates the relevant documents from the universe of similar documents. With the bulk collection of telephony metadata, the government statement of fact merely articulates a supposed value in collecting data on every call. There are no facts to differentiate the calls that are more likely to relate to the government's investigation from every other call made by innocent Americans. The government's interpretation is so broad that ultimately conflates relevance with utility. The records are relevant because the government believes that it needs them. If this was Congress's intent, it would have said as much. Returning to and distilling the government's description of relevance, quote, relevance is a broad standard that permits discovery of large volumes of data where necessary to identify much smaller amounts of information, unquote. You'll notice that while this describes our fertilizer hypothetical, it also allows for any collection, no matter how large, that includes at least some relevant data. The government's interpretation actually creates a perverse incentive to over-collect records because a larger volume of data is more likely to include relevant material. And that is exactly what the government did. And worse, it happened in secret. General Michael Hayden, the former director of both the NSA and the CIA, and one of the architects of the government's bulk collection program, frequently argues that the bulk collection program checked all the constitutional boxes. He calls it the Madisonian trifecta because there was a law passed by Congress, implemented by the administration, and approved by a federal court. He means this as a defense, but he actually identified a problem. The administration managed to create an illusory of normalcy to justify a process that is anathema to our democratic and constitutional government. The administration had, in fact, misconstrued a congressional statute and relied on a hand-picked court of friendly federal judges that operates both ex parte and in secret. I am certain that Madison never dreamed of this. And sure enough, once the program became public, two legs of this three-legged stool instantly became unscrewed. When given the opportunity to vote directly on bulk collection, Congress overwhelmingly rejected it. Similarly, the only federal court to consider the government's statutory interpretation of the relevance standard ruled that it was illegal. In ACLU versus Clapper, the Second Circuit agreed that the phone records of every American are not relevant under Section 215. The court wrote, quote, "The records demanded are all-encompassing. The government does not even suggest that all of the records sought, or even necessarily any of them, are relevant to any specific defined inquiry," unquote. Faced with this problem, I set out to draft legislation that both ended bulk collection and reformed the process that led to this misinterpretation of the law. The result was the USA Freedom Act. The Act ended bulk collection by adding a new requirement that the government include a specific selection term as the basis for production of all the government's domestic surveillance authority. While virtually every line of the Act's text was subject to scrutiny and negotiation, there was no aspect that garnered more intense focus than this definition. Drafting the statute, it became clear that bulk collection was less about the exact quantity of tangible things sought than the indiscriminate nature of the collection. As described earlier, this was the critical distinction between the government's metadata collection and our fertilizer hypothetical. The metadata collection is considered bulk, while the fertilizer hypothetical is not, because the collection of fertilizer sales is no broader than necessary for the purpose of the investigation. USA Freedom builds upon this understanding and defines a specific selection term as, quote, specifically identifies a person, account, or personal device, and is, quote, used to limit to the greatest extent reasonably practicable the scope of the tangible things sought, unquote. Thus, the law does not put a cap on the total number of records, but instead limits the collection to the greatest extent possible. The relevance standard should have required the government to produce specific facts that separated the necessary documents from the broader universe of similar documents. Because the government ignored that, we codified the definition and we codified the limitation. The standard requires a case-by-case fact-specific determination by the FISC as to whether the government's request is limited to the greatest extent reasonably practicable. We extended this limitation to all the domestic surveillance statutes so the government could simply not transfer its bulk collection program to a different authority, meaning shifting the statute that was used to justify bulk collection. Finally, we introduced significant new transparency and declassification standards, as well as an amicus panel of privacy advocates to operate within the FISC. We began work on USA Freedom soon after the Snowden leaks were made public. Last year, Representative Justin Amash from Michigan introduced an amendment to the annual defense appropriation bill that would have stripped the NSA funding for its implementation of Section 215. Despite heavy lobbying against the amendment from the leadership of both parties and from the White House, the amendment was barely defeated in the House by a vote of 217 to 205. The narrow political defeat was a clear signal that there was strong desire for reform. This signal was augmented when I introduced the USA Freedom Act that fall. The bill attracted 152 House co-sponsors, as well as the support of technology companies and privacy groups. Importantly, 12 of the bills co-sponsored had voted against the Amash amendment a few months earlier, more than enough to have reversed the outcome. While the depth of support was less clear in the Senate, Senator Patrick Leahy of Vermont introduced an identical companion bill. From the beginning, the surveillance debate exposed unusual Washington allegiances that were more grassroots versus leadership than traditional partisanship. The White House and the leadership from both parties opposed the bill upon introduction, but it was supported by some of the most liberal and some of the most conservative members of Congress. Passing any legislation is difficult in the current political climate, but it is exponentially more difficult when the legislation in question is opposed by leadership in the administration. Members supporting the bill, however, joined by outside privacy groups and tech companies, were putting constant pressure on Congress for reform. In February of 2014, a large group of technology companies and privacy groups organized an event entitled The Day We Fight Back, in an effort to encourage Congress to vote on the USA Freedom Act. I published 8 op-eds to build momentum, and there was a slow leak of disclosure from the Snowden documents keeping the need for reform in the news. Senator Feinstein, then the chairwoman of the Senate Intelligence Committee, attempted to recapture the conversation by introducing the Fisa Improvement Acts. The bill opened by stating its intent to end bulk collection, but listed numerous exceptions that allowed the administration to maintain the status quo. Senator Feinstein easily moved the bill through her own committee, but it was widely panned by editorial boards and the outside groups, and it never received a vote on the Senate floor. Adding to the pressure for reforms were the sunsets that I included in the original Patriot Act of 2001. Section 215, along with 2 other surveillance authorities, roving wiretaps and lone wolf, were scheduled to sunset on June 1st of this year. Increasingly, reform appeared to be the only way to save these authorities, and USA Freedom appeared to be the only acceptable vehicle for reform. Actual movement came when Chairman Mike Rogers of Michigan of the House Intelligence Committee announced that he would move his own Fisa reform bill, the Fisa Transparency and Modernization Act. The bill was carefully structured, but only to maintain the status quo for current surveillance programs. And he did so in a way that avoided triggering jurisdiction with the House Judiciary Committee. With its oversight of the judiciary and federal law enforcement, the Judiciary Committee has been historically the primary committee of jurisdiction for surveillance authorities. The intelligence bill, therefore, was not only a dramatic substantive departure from USA Freedom, but also a significant jurisdictional shift. While nuanced, the issue of committee jurisdiction is significant. Different committees have drastically different perspectives. The Judiciary Committee is composed primarily of lawyers. Their perspective is shaped by their legal backgrounds as well as by their primary focus of overseeing federal law enforcement, such as the FBI and DEA. Judiciary Committee members are typically well-versed in the Constitution and constitutional rights and view the government's interaction with the public through the prism of criminal law and its history and regard for individual rights. The Intelligence Committee, by contrast, has primary jurisdiction over the CIA and NSA. Its perspective is similarly shaped by these relationships, their focus on clandestine activities, and the need to collect intelligence. A jurisdictional shift from the Judiciary to the Intelligence Committee could therefore have had a profound effect on the substance of our surveillance laws. As a result, the Intelligence Committee's decision proved to be a crucial motivator to convince House Judiciary Chairman Bob Goodlatte of Virginia to move the USA Freedom Act. The 2 committee chairs announced their intention to mark up the competing Fisa reform bills on the same day. To avoid this conflict within the Republican caucus, then House Majority Leader Eric Cantor organized a meeting with Chairman Rogers, Goodlatte, and myself and asked that we reconcile the differences between our dramatically different bills. Because a substantial majority of the House of Representatives favored reform, the USA Freedom Act became the basis of negotiations. We worked closely with the Intelligence Committee to narrow the text while still maintaining the bill's core functions. The negotiated bill passed the Judiciary Committee unanimously on May 7, 2014, and the Intelligence Committee passed an identical text. The period after the committee votes led to another intense round of negotiations with the administration and the House leadership. The result was compromise legislation that neither side thought perfect. Importantly, the bill for the first time received the unqualified support of the White House. Unfortunately, the bill lost the support of many of the key privacy groups and technology companies. Thus, while the USA Freedom Act easily passed the House of Representatives 303 to 121, it did so without some of its strongest original patrons. Because so many privacy advocates and technology companies pulled their support from the House-passed version of the USA Freedom Act, Senator Leahy had the opportunity to reopen negotiations with the now supportive administration. Senator Leahy succeeded in updating the bill and rebuilding the original coalition of privacy groups and technology companies. Despite this coalition, the bill ultimately failed to meet the 60-vote threshold for cloture in the Senate. The USA Freedom Act thus died in the 113th Congress, despite support from 303 members of the House and 58 senators. The Senate vote could have been the end of reform. Because, however, 3 surveillance provisions from the Patriot Act would sunset on June 1st of this year, there was a continued need to address privacy concerns stemming from government surveillance. In early 2015, we began bipartisan, bicameral negotiations to reconcile the House-passed version of the USA Freedom Act with the updated version introduced by Senator Leahy. On April 28th of this year, I reintroduced the USA Freedom Act along with Congressman Goodlatte, Conyers, and Nadler. Prior to introduction, we had reconciled the differences between the House and Senate version of the bill with Senators Leahy and Lee, and then with Chairman Devin Nunes, the new chair of the House Intelligence Committee. On May 13th, the House of Representatives again passed the USA Freedom Act, this time with 338 in favor and 88 opposed, which was 35 votes better than the vote on a similar bill last year. The overwhelming support was an important statement for the Senate. With the sunset of the Patriot Act surveillance authorities on the horizon, the Senate nonetheless dug in against the Freedom Act. Majority Leader Mitch McConnell, along with Senate Intelligence Chair Saxby Chambliss and Senate Judiciary Chair Chuck Grassley, pushed for a clean, unamended reauthorization of the Patriot Act. That means simply striking out the June 1st expiration date of the 3 expiring authorities and putting a date in later on. Meanwhile, Senator Rand Paul drew a hard line on the other side and advocated for a complete sunset of the whole bill. These tensions came to a head when Majority Leader McConnell brought the Freedom Act to the Senate floor on May 22nd, just over a week before the expiration of the Patriot Act authorities. Heavy lobbying from Senate hawks led to a narrow defeat on a procedural vote, with 57 senators voting to proceed to debate the Freedom Act, which was 3 votes short of the 60-vote threshold. Senator McConnell then attempted to pass a 2-month reauthorization of the expiring authorities. The Senate, however, easily defeated that. He then proposed a 1-week extension, but Senator Paul objected, thereby blocking the vote. He then suggested an extension of June 5th, which was 5 days. Senator Wyden objected. Then McConnell tried for June 3rd to have Senator Heinrich object. And finally, the Majority Leader asked for an extension through June 2nd, and Senator Paul objected to even a 24-hour extension. Exasperated, Majority Leader McConnell announced that the Senate would reconvene on May 31st, which was a Sunday, just hours before expiration. Senator McConnell filed several amendments designed to weaken the civil liberties protections of the bill. Senate rules, however, would not allow a vote on either final passage of the bill or the amendments until Tuesday, June 2nd. As a result, the 3 surveillance authorities from the Patriot Act temporarily sunsetted at 12:01 a.m. on June 1st of this year. Any amendments to the House bill would have at least delayed reauthorization, as the Senate would have had to take up the Senate amendment bill. And there was no guarantee that the House would have accepted the changes. Because his fellow Republicans did not want to take this risk, Senate Majority Leader McConnell was bucked by his own party in the Senate, and they voted down each of his amendments with a simple majority vote. The Senate then passed identical language as the House, sending the bill to the White House, where the President promptly signed it upon receipt. Now, just as we are naive to ignore the very real threats to our national security, we would be equally naive to ignore the very real encroachments our government made on civil liberties at perilous times in our country's history. This is not the first encroachment in our history. I am sorry to say that probably won't be the last. Under the government's definition of relevance, the government can indiscriminately collect and store data when it believes the databases are potentially valuable. Once the FISC accepts this construct, the line becomes the administration's to draw. Limits on government power matter, and maybe more importantly, how those limits are drawn matters. If the government is to conduct bulk collection, it should be a democratic choice made by elected officials who are accountable to the voters. The USA Freedom Act represents a clear political product, drafted to equip the intelligence community with the tools it needs without unnecessarily compromising privacy or civil liberties. There is no perfect place to draw the line between privacy and national security. The Constitution, however, establishes that the political process is the perfect way to draw it. This was the intent of both the USA Patriot and Freedom Acts. Whether you disagree with one, the other, or both, there is a clear public record so you know who exactly to complain to. More than any specific product, this process is what we must fight to maintain as we debate future laws and programs designed to protect our national security. So thank you very much for your attention. We will have some time for questions and answers. Who is the person who has the hook to shut that down? Because I don't want, okay. I don't want to be the bad guy on it, so yeah. Thank you. Yeah.